What's new in the Patent Amendment Rules 2016? As we had already mentioned, the Patent Amendment Rules 2016 was the latest amendment to the rules that came into force. Earlier to that, the Patent Rules 2003 was amended many number of times, and all these amendments we had already mentioned makes it easy for the law to be changed wherever there is a requirement. We find that the 2016 amendment rules introduced many new things into the patent rules. We will find that for the first time we have the definition of startups mentioned in Rule 2. Rule 2 definition, Rule 2 FB defines a startup as an entity that has existence of less than 5 years from incorporation. Now, we use the word incorporation, we understand that the entity could either be a private limited company under the Companies Act or a registered firm registered under section 59 of the Partnership Act or under the Limited Liability Partnership Act 2002. Now, this gives a startup the status of a entity. So, individuals are excluded. We get this from the explanation 2 to the definition. Individuals are excluded, and similarly any kind of association of people which cannot come under these three categories will also be excluded. So, to claim a startup you need to be an incorporated entity, something which came into being by the force of law. Could be a company, could be a partnership firm, or it could be a LLP, a limited liability partnership. So, incorporation is important, and you will find from the definition that the status of a startup can exist only for 5 years. So, it is time bound and the 5 years start from the date of incorporation. That is the first requirement. The second requirement, the turnover in the last 5 years should be less than 25 crores of rupees. So, the turnover of that entity in the last 5 years should be less than 25 crores. If it exceeds 25 crores, then it ceases to be a startup. The third requirement is that the startup should be working towards innovation, development and commercialization of new products or processes. So, it is a requirement that it is working towards innovation, development, deployment or commercialization of new products, processes or services driven by technology or intellectual property. So, that is a part of the third requirement, that a startup should be driven by technology or intellectual property. So, if the entity is not doing anything pertaining to technology or intellectual property, then it may not be able to avail the status of a startup. Now, we will soon tell you how to avail this status, but this definition and the concept of a startup was introduced by the 2016 Amendment Act. The definition also tells us what will not qualify as a startup. For instance, if the product and services do not have the potential of commercialization, then that is not something which will be factored into the status of a startup. If the products are undifferentiated products and or services or processes, they are undifferentiated, there is nothing unique about them, it is what everybody else does, then again you will not get the status of a startup for the purposes of the Patents Act. And the product and processes with no or limited incremental value for customers or workflow would not be covered under this definition. So, the value that the company produces is either there is no value or limited incremental value for the customers or for the workflow. So, these are the instances. So, a startup status under the Patents Act is different from a normal startup status. For you to be a startup under the Patents Act, you need to be concentrating on sectors pertaining to technology or intellectual property. So, your products or services or processes should be driven by technology or by intellectual property. So, this differs, whereas a startup could also be for a social cause, a startup could be for anything, but under the Patents Act the definition gives a clear meaning and it categorizes startups as being driven by technology or intellectual property. Now, explanation 1 tells us when the status of a startup will cease. Now, it goes beyond 5 years, as I already mentioned. The status of a startup will no longer be there, and if the turnover in any of the previous year exceeds 25 crores, then again it will not be entitled for a startup status. We saw that it should be less than 5 years from the date of incorporation, which means the entity came into being by a legal process of incorporating a company, registering a partnership firm, or registering a limited liability partnership. Now, incorporation is important because the definition also tells us that you cannot form an entity by splitting up or reconstructing an existing business. So, if there is an existing business, you can't reconstruct it, reincorporate it in a new name and call it a startup, and you cannot split up an existing business. For instance, a big multinational company cannot now demerge or create a smaller entity and say that this is a startup, we should avail all the privileges of a startup. That cannot happen. Then the term turnover, we said the turnover should be less than 25 crores. It takes the meaning of the same word turnover under the Companies Act. So, there is a cross reference to the Companies Act 2013 for understanding what turnover means, and there is also some reference rates of foreign currency will be as stipulated by the Reserve Bank of India. So, if a foreign entity is claiming a startup status, so the similar test will be applied for the foreign entity. If you want to know turnover, if the sales are abroad, so you could use the same rates as stipulated by the Reserve Bank of India. Now, what does it mean to state that the entity is working towards innovation, development, deployment or commercialization of new products, process or services driven by technology or intellectual property? This is further explained in explanation 4, that it means that it aims to develop or commercialize a new product or a process or service, or significantly improve existing product or process that will create or add value to the customers or workflow. Now, this kind of overlaps with the definition of an invention. The invention is normally granted for a new product or a process, or an improved product or a process. These are the two large categories, broad categories for which inventions are granted patents. So, the status given to a startup is very similar to the definition of invention itself. So, the startup should be working on developing new products and processes, which is what inventions should be, or at least it should be significantly improving existing products and processes. Improvements can be filed as patents for existing inventions. So, these two categories are covered. Explanation also goes on to say that it should create value to customers or workflow, which is something kind of an utility requirement. So, the product that is patented has to be useful, or it should be capable of industrial application. So, to that extent, explanation 4 maps over or overlaps with the definition of an invention itself. Now, how do you claim the status of a startup? If you are a startup, how do you claim that status? For that, there is a new form that has been introduced, that is Form 28. Form 28 is filed, it is submitted by a small entity or a startup. If you are a small entity under the Micro, Small and Medium Enterprises Act 2006, or if you are claiming that status, or if you are claiming the status of a startup, you file Form 28. So, the requirement for claiming a startup also involves filing Form 28, and in Form 28 you have to give a document that will evidence the eligibility of a startup. So, it is not just filing the form. If you have been incorporated since 5 years, you have to produce that your certificate of incorporation. If you are claiming the startup status because your turnover has not exceeded 25 crores, then you may have to file the returns over the last few years. And similarly, if you have to show that you are working on areas driven by technology and intellectual property, you may have to produce some proof to that effect. So all the three requirements in the definition, less than 5 years from incorporation, which will require a certificate of incorporation, turnover being less than 25 crores may require producing the annual returns or the tax returns, and working towards innovation and development of new products, processes and services driven by technology and intellectual property, which is the third leg of the definition, would require some description of the nature of the work done by the entity. Nature of work, nature of products, services rendered, processes in place, all these things you could produce document, because the form clearly says that there has to be a document produced for claiming the status of a startup. Now, what do startups get? Why should somebody file patents as a startup? What will be the advantage of getting the status of a startup? Now, the first advantage that startups get is that they will be treated at par with an individual or a natural person when it comes to the fees that an entity has to file. We know that there are 3 categories of fees under the Patents Act and rules. Now, first schedule deals with the fees payable. So, the 3 categories of fees are: 1, we have a particular structure for a natural person or a startup. So, the startup gets treated like a natural person. So, the fees are the lowest, you start with the lowest fee. If you are a small entity alone or with a natural person or a startup, so if you are filing it, anybody files with a small entity, then the fee is slightly higher. Now, just to give you the instance for e-filing, so we have a separate structure for e-filing and a different structure for physical filing, and e-filing is normally cheaper than physical filing. So, if a startup or a natural person makes a patent application under form 1, then he needs to pay 1600 rupees. Whereas, if an application is filed as a small entity, then the fee is 4000 rupees. That is the third category. Any other entity other than startup, a natural person or a small entity, which will include all big organizations, research organizations and corporations, then your fee is 8000 rupees. So, the first benefit a startup gets by filing an application using its status as a startup is it is entitled to a, despite being an incorporated entity, it is entitled to a reduced fee rate, and the fee rate is same as that of a natural person. That is the first advantage. The second advantage a startup can avail because of its status is that it can avail itself the privilege of an expedited examination. Expedited examination is where you can fast track your patent application. So, under Rule 24C, we will find that expedited examination can only be filed by an entity that is a startup. This privilege is not open for any other entity, but any other entity can avail expedited examination if it has indicated India as the competent international search authority or elected India as the international preliminary examination authority in the corresponding international application, which means that entity which is not a startup will have to file an international application choosing India either as the ISA, that is the International Searching Authority, or the IPEA, the International Preliminary Examination Authority. Now, we know that India became an International Search Authority and an International Preliminary Examination Authority recently. So, if you need to fast track your application, you could do that if you are a startup. If you are not a startup, then it means you need to file an international application. So, domestic applications, what we call applications filed in India alone, cannot be expedited if you are not a startup. It requires to avail an expedited examination, it requires the entity to file an international application. The international application may be filed and claim the expedited status. They may expedite the examination and later on abandon the international application. It is completely left to what the entity wants to do, but expedited examination is only open for startups. Other entities will have to claim it in a different way, that is by filing an international application and choosing India as the ISA or the IPEA. The second thing that was introduced by the 2016 amendment was there was a change in the address of service. Now, under Rule 5, the applicants are required to furnish their email address and mobile number. So, this is a Rule 5 made a change to the way in which communications happen. So, every person concerned with any proceeding or every patentee shall furnish to the controller address including email address. Now, this was introduced by the new rules, and the proviso says the patent agent shall also be required to furnish to the controller a mobile number registered in India. So, the email address is of the clients, but the mobile number is for the patent agent. Now, leaving and serving documents. Rule 6 tells us about how to serve documents and how to leave documents when you are dealing with the patent office. Now, earlier courier service was an option open to sending communications to the patent office. That has now been removed. Courier service has now been removed. So, you can no longer send things to the patent office by way of courier. It has to be through post or registered post or speed post or electronic transmission duly authenticated. So, these are the ways in which you can do it. Courier service has been removed. That is a change that the 2016 Act introduced. 6(1)(a) 6(1) says the various ways in which you can do it. 6(1)(a) did create some controversy because it said that notwithstanding anything contained in Rule 1, a patent agent shall file, leave, make or give all documents only by electronic transmission duly authenticated. Now, duly authenticated means that the patent agent should have a digital signature with which he will do the electronic filing, including scanned copies of documents that are required to be submitted in original, provided that the original documents that are required to be submitted in original shall be submitted within a period of 15 days, failing which the documents would be deemed not to have been filed. You need to make a note there, that is another deeming provision under the Patents Act. We had already told you that there are various deeming provisions: deemed to have been abandoned, treated to be abandoned, treated as withdrawn. This is another deeming position. So, even if you make an electronic application, if you do not follow it by filing the physical documents, that the original documents physically, if you do not file them, send them by post, then it would be deemed that the application was not filed. So, one thing to note about electronic filing is that electronic filing is not electronic filing in the sense of its word. It means that it is an electronic filing followed by physical filing. And this issue came up because now if you are a patent agent, the only way you can file is electronic. So, to that extent there is now another layer the patent agents will have to go through, because the patent agent who were filing the applications physically will still have to file it physically within 15 days, but they also need to file it electronically. So, that is an extra thing that has been introduced. There is a new provision on condonation of delay or condoning delay. There is a petition for condoning delay. Now, the controller is given the power to condone delay in transmission and resubmitting of documents to the patent office. Now, period of condonation shall not exceed period of national emergency was in force or 6 months from the expiry of the prescribed period. Normally, if there is a national emergency and there could be a moratorium on doing certain acts, if there is a natural disaster or a calamity and people are not able to move around, or there is a power shutdown or blackout, in all these instances there can be cases where a delay in filing can be condoned. Now, the provision says that it shall not exceed the period of the emergency or 6 months from the expiry of the prescribed period. So, the details are given in Rule 6.6. There are some changes to the fees. We had mentioned that the new fee structure for startups were introduced. Apart from that, in Rule 7, which deals with fees, fees shall be deemed to be paid when post actually reach the controller. When the post actually reach the controller, that is the time fees is deemed to have been paid. This is in cases where the draft or a banker's check is sent by post. What this makes, when the banker's check or the draft actually reaches the controller, that is the point at which it is deemed to have been paid. There is an option of paying it either in cash at the patent office or through electronic means. These two options are also open in addition to sending a banker's check or a bank draft. Another new aspect that was introduced in the rules by the 2016 amendments was, in case you paid excess fee for a same proceeding, it can now be returned. There is a provision by which there can be a refund. So, there is a provision for refunding excessive fees. This is upon the satisfaction of the controller that during the online filing process, the fee was paid more than once for the same proceeding. There is also a provision for refund of fees in case of a withdrawal of an application. You can withdraw an application any time after it is filed before the grant. Now, the withdrawal should be in respect of which there has been a request for examination. So, you have filed an application, you have made a request for examination, but the patent office has not issued the first statement of objection. Now, this is the point at which if you withdraw, then the fee will be refunded to you. If you withdraw the application after the first statement of objection is filed, then this provision will not apply. You will not get a refund. The reason being, the patent office has actually started working on your application. So, if you withdraw it before the issuance of the first statement of objection, then you are entitled to a refund. Now, to claim the refund, you will have to file Form 29. Form 29 is a newly introduced form for withdrawing the application under section 11B4. In the first schedule, there are two tables. Table 1 deals with the fees payable. Table 2 you will find at the end of table 1, after table 1, that is after entry 53 of table 1, you will find table 2, which talks about fees refundable, fees payable and fees refundable. These are the two tables. Now, in fees refundable, you will find that the refund of fees under Rule 7 sub Rule 4A, which can be done by filing Form 29, 90% of the fee paid for request for examination or request for expedited examination will be refunded. So, the fees which you paid for request for examination or a request for expedited examination will be refunded if you file an application for withdrawing the patent under Form 29 before the issuance of the first statement of objections. There is a new provision with relating to biological material. In Rule 13.8, the period within which reference to deposit shall be made in the specification under subclause A of clause 2 of subsection 4 of section 10, that is 10.4.2a, shall be 3 months from the date of filing the application, provided that in case of a request for publication under Rule 24A, a reference shall be made on or before the date of filing such a request. Now, this proviso was not there before. What has been introduced here is the proviso, provided that in the case of a request for publication under 24A, such reference shall be made on or before the date of filing such request. So, you file an application, date of filing is normally you have to make a reference within 3 months from the date of filing the application. Now, if you have made a request for publication, wherein you want to expedite the publication quickly, then such reference shall be made on or before the date of filing such request. So, if I file an application in January, I am expected to make the reference to the deposit in the specification within 3 months from the date of filing the application. Now, if I do not do that, or if in Feb I take a publication under section 24A, I make a request for publication under 24A the next month itself, then before I make that request, I will have to make the reference. Normally, I have the 3-month period. The 3-month period gets shortened if I take a request for publication under Rule 24A. So, the proviso now says, if you want to expedite it quickly, if you want to publish the application, then the reference has to be made along with the request for publication. So, you could have a question where biological material is mentioned, and in the situation they say that of the choices that you have, the situation says that you are in a hurry to publish your application. So, you file a request for publication along with your application itself. So, in such cases, what should you do with regard to the reference? Choice A, you have 3 months from the date of filing. Choice B, you should have made the reference at the date of filing itself, and so on. So, depending on the problem, you would now have to answer this. Now, the question could also say that if Form 9 is filed in a case where involving biological material, then at what time or what is the period within which the reference to the deposit should be made. So, you just say Form 9 is filed, it should be along with Form 9 or along or before Form 9, after Form 9, 3 months after Form 9. So, only a person who knows this provision will be able to answer that. It has to be on or before filing Form 9. Okay. So, here it says request for publication, but you can make if the question is trickier, then you will just have this said. Should it be, one of the choices could be on or before filing Form 9. So, this makes the question tougher because the person will have to know what is the rule on biological material, he will have to know what Form 9 is, and he will have to relate this provision that, and you could also give a confusing choice by saying that 3 months from the date of filing Form 1, okay, which is true. In a normal case, it has to be done, the period of reference is 3 months from the date of filing Form 1, but you could now make the question by saying, if the party wants to makes a request for publication, then what should be the timeline? It should be on or before filing Form 9. So, you could just mask all the provisions with the forms and you will have a tough question to answer in that case. Amendments of specification. Now, in Rule 14, this was the change that was introduced. A marked copy clearly identifying the amendments carried out and a statement clearly indicating the portion, page number and line number of the specification or drawing being amended along with the reason shall also be filed. Now, 14.2 introduced this. So, this was the change that was incorporated into Rule 14 by the 2016 amendment. Deletion of claims with regard to international application, designating and electing India. Rule 20, there were some changes made in Rule 20. Deletion of claim at the time of a national phase entry should be in accordance with Rule 14. Examination of application, again we find that FER, the first examination report, which is now universally called the first statement of objection, the time period, there is a change, issued within 1 month from the disposal of the examination report by controller. So, there is a time period of 1 month which has been introduced. This you will find in Rule 24B3, and the time for putting the application in order for grant reduced to 6 months. Okay. Earlier it was 1 year, now it has been reduced to 6 months, and the further extension is by 3 months. So, the timelines have been shortened. Expedited examination has been introduced. 24C. There are some changes with regard to hearings. Rule 28 now allows for hearing through video conferencing. People who have been practicing in the patent office will be now aware of a new procedure where patents filed in any appropriate office are now taken up for examination in different offices. So, you may file an application in Chennai, but the examination process could happen in Delhi. So, to facilitate, it is not necessary that agents should physically be present during hearings. They have now brought in hearing through video conferencing. There is also a provision for filing relevant documents between 15 days from the date of hearing. So, you have a time period to file documents even after the hearing. So, that has been again introduced by the new rules. And for adjournment of hearings, Rule 129A, a request has to be made 3 days before the hearing. There cannot be more than 2 adjournments. An adjournment may not be for more than 30 days. This is again to streamline the procedure and to reduce the delay in the prosecution process. Scientific advisors. Rule 103A now introduces disqualification for inclusion in the role of scientific advisors. 103A now tells us that a person who has been adjudged by a competent court to be of unsound mind, an undischarged insolvent, a person who is bankrupt, being a discharged insolvent, has not obtained from the court a certificate to the effect that his solvency was caused by misfortune without any misconduct on his part. That is a third category. So, even if you are a discharged insolvent, but you have not got a certificate, a person convicted by a competent court, whether within or outside India, of an offence that to undergo a term of imprisonment unless the offence for which he has been convicted has been pardoned by the central government, or for guilty of professional misconduct. Now, if these 5 disqualifications are there, then the person shall be removed from the role of the scientific advisors. Some of them are of moral nature, some of them are physical, like unsound mind. A person of unsound mind cannot be an expert, and scientific advisors are actually experts who help the court in patent litigation. Power of attorney, there is a change in the power of attorney. 135(1) has been substituted. Earlier, before its substitution, 135(1) just said the authorization of an agent for the purpose of this act and the rule shall be in Form 26 or in the form of a power of attorney. Now, it says shall be in Form 26 or in the form of a power of attorney within a period of 3 months from the date of filing the application or document, failing which no action shall be taken or such application for further proceeding till the deficiency is removed. Okay. So, the 3-month period has now been introduced, and this is important for us to understand because this may be used for filing patent applications and not processing them despite preserving the priority. Now, assume a hypothetical case where a person files a complete specification. He files the complete specification, everything is in order, he gets a number, he pays the fees, everything is done except for filing the power of attorney. Now, what does the Act say? In the other cases, we saw deeming provision would say deemed not to have been filed, deemed to have been abandoned, deemed to have been withdrawn, treated as withdrawn. This provision does not use any of that language. It does not say it will be abandoned, it will be treated as withdrawn. Rather, it says no action shall be taken till the deficiency is removed. So, the only penalty here is no action will be taken till the deficiency is removed. So, this could lead to applications being filed, and for whatever reason, if an applicant wants to keep his application in submarine mode is it does not get published for a long time. Normally, we know that after 18 months it has to be published. Say he wants to keep it unpublished for a longer time. This provision could be used, you can even say misused, if we go by the word meaning here. You need to file an application and not file your power of attorney. The application will be only acted upon when you remove the defect. The understanding is that your priority, everything else will be preserved, because once the patent office deems something to be abandoned or deemed to be not filed, like the provision that we saw, then the consequences can be different. So, the only consequence is no action will be taken till the deficiency is removed. There are a couple of forms. The Form 1 has been amended, Form 3 has been amended by the 2016 amendment rules, Form 4 has seen some amendment, 13 has also seen some amendment, 18A has seen some amendment, 28 has seen some amendment. Form 29 is a new form which is for withdrawal of an application, and there is a connected refund if a person is eligible for it. And Form 30 has also been introduced. Form 30 is a generic form which can be used wherever no form is prescribed.